Okay, I'll go ahead and let Mr. Hathaway in.
Morning.
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 Good morning, Mr. Hathaway. My name is Andrew Morgan. I am chair of the 7th Circuit JNC, and I want to get things started this morning by asking you to introduce yourself to the other commissioners and to tell us why you want to be a county court judge.
Sure. First, I want to say thank you all very much for the opportunity and the privilege to address you. I know that this is a difficult job you all have, and often a thankless one. I appreciate the effort I know you all put into this process, and it's a privilege to be here. My name is Spencer Hathaway, and I currently serve as one of your managing assistant state attorneys for the 7th Circuit State Attorney's Office. I work for R.J. Larissa. My current assignment is I'm the managing attorney for misdemeanor, juvenile, specialty courts, first appearances, and I'm a member of the executive team in the Daytona office. I get the opportunity to work with some of the finest attorneys that work in this circuit. I get to serve my community, and that dovetails into the second part of your question, why I want to be a county judge. Basically, service to my community is ingrained in my DNA. My grandfather served as a captain in the United States Army, was decorated in World War II. He helped fight fascism and oppression worldwide, came back and ran for mayor of New Smyrna Beach. He served in the 60s as a mayor, opened a grocery store. His children, my father and my uncle and my aunt, they all went to college and got college degrees to serve their community after his example. My dad was mayor of New Smyrna Beach. My uncle still is an attorney, was an assistant state attorney, now is in private practice in criminal defense and family law, and I worked with him. And my aunt was a school teacher. That desire to serve our community has passed through to the next generation. And my sister's a school teacher. My brother's a deputy sheriff for Volusia County, and I'm privileged to serve as an assistant state attorney now. I believe that my unique experiences and my resume uniquely qualify me to serve as a county court judge for a number of reasons. I manage a huge caseload now of all of the East Side misdemeanor cases. I've been a private defense attorney. I've been a court-appointed defense attorney. I've done civil cases. I've been in private practice on 2 separate occasions, and I served as a special magistrate while I was in private practice. My primary motivation is to make my community a better place, to make it better for my children than when I got it. And ultimately, my sole motivation in everything I do is my family. Whatever I can do to make my family in a more secure and safe place, whether that's improving the safety of the community, whether that's making the system that serves the judicial arena more efficient, more effective, then that's my calling. And that's how I refer to this. This isn't a job. This isn't a profession. This is a calling. And like many of the folks in this room, I understand that you all have dedicated your lives to the law because it's something that's greater than us. It's something that means more than just going, punching a clock and doing a job. This is a calling to improve our community as a whole. And I'm happy to answer any and all questions that you might have about my application and why I'm here today.
Mr. Hathaway, I had the pleasure of vetting you, so I have some questions, and I don't want you to take any of these things the wrong way, but I feel like if something's going to be raised in deliberations, I anticipate it would, I should always give a candidate the opportunity to kind of give us their take. And so one of the things that is, the number of years you have been a lawyer. And I don't think there's any, obviously the law doesn't have a requirement that says you haven't met it. But there's, certainly lawyers understand that having experience can often be helpful in being a judge. But it's not necessary. So what is it that you think qualifies you or would make you a good judge, even though there's others on this list who may have been a lawyer longer than you?
Absolutely, and I appreciate that question. I've done a lot in my 9 years as a practicing lawyer, and absolutely there are folks on this list that have more years of experience than I do. Uh, but I think it's important not just to look at the years of experience, but look at the experience in those years. And in 9 years, I've done a number of different legal jobs. I've done just about every case a county judge would hear. I've done a significant amount of trials. I've done a significant amount of motion practice. I've done a management job that covers everything on the spectrum at the state attorney's office, from misdemeanor filing decisions to complaint affidavit cases, all the way up to the death penalty and everything in between. And on the administrative side, we handle all the HR, the budgeting. We're making truly life and death decisions at this office and the executive staff, and I get to be a part of that. As I stated before, I'm not just a prosecutor. I have been a defense attorney. I've learned from some of the best attorneys in the world. I've been in front of every single county judge in Volusia County for a substantive hearing, trial, or case. I think aside from Chris Miller, I don't think I've appeared in front of Chris, but I think I've appeared in front of the rest. I was in a pretrial this morning in front of Judge Totten. I've handled thousands and thousands and thousands of cases. I've tried homicide cases. I've represented people on the other side. I've done defense work on a manslaughter case. I've done defense work on aggravated battery, child molestation, child pornography cases. I've run the gamut in a short period of time. And while I think if 5 years from now, if I were in a, let's say, an intake position and I was making filing decisions, I think in 5 years, I'd be less qualified doing that work than I am today. I'm in the trenches every day with my prosecutors. I'm in the trenches every day in the courtrooms. I know what it takes to manage a massive caseload. I know what it takes to do more with less, to embrace technology in the face of COVID-19. We have been on the forefront of how we adapted as a state attorney's office to make the system more efficient and more effective. And like I said, I meet the yearly requirement that's in the law. And I think if you put my experience, even though it isn't maybe in a shorter time than some of the others, I put my resume against anybody else. And if I didn't think I was qualified, I wouldn't have applied.
What about your civil experience? What civil experience do you have, and how would you handle, landlord-tenant issues, small claims, and now the higher jurisdictional limits for county court?
Sure. So my first year out of law school, I was with a civil firm. We did landlord-tenant, we did local government, we did municipal ordinances, we did small scale civil litigation, small claims, credit card things. Then I was a prosecutor for 5 years, left for another year, and did the same kind of general practice. It would be obviously my focus in the majority of my career has been criminal. And I understand that if I'm honored and selected to be forwarded to the governor, and I'm honored and selected by him to serve, I'd likely do a stint in civil before I ever went to criminal. It would require me to hit the ground running with a bit of homework. I mean, I'm gonna have to refresh myself, obviously, on the rules of procedure for civil and small claims, get familiar with the PIP litigation again. I have done these things. It hasn't been recent, but I am a quick learner. I'm a hard worker. I will get back to Jump Street for day one. It won't be a difficult transition. The rules of evidence will be the same. The procedure is fairly similar, but I have done these things. I'm the first to admit it has not been my primary practice and my primary focus, but the increase in the limits on the jurisdictional amounts is going to increase the caseloads. And that's the same for the civil docket, where it went up to $30,000, and on the criminal side, where the grand theft numbers have gone up and the DWLS charges that were traditionally felonies are now being trickled back down to misdemeanor. So it's adapting and being flexible, knowing that the system has changed. The approach to how we handle cases in county court has changed, and the pandemic that we're dealing with right now has obviously impacted it. Utilizing technology, being familiar with the Zoom court proceedings, which we were on the forefront of doing it, and being flexible with docket management, ensuring that substantive and procedural due process are protected, and that's paramount, and secondarily, making sure you're efficient. So that's how I would approach a civil docket.
Another question for you. There's a case in here, and I want to drill a little deeper. State of Florida v. Decker, and that's a case where you made a decision to not move forward in an aggressive way, which is judges get put in this position, especially on a criminal bench, where you're having to figure out how do I sentence somebody? How do I put a GPS on it? Conditions of release. And so all these kind of intangible decision making that go on in a judge and their job. Tell me a little bit about that case and how you decided to do what you did.
Sure. That case, I think I included in the application. I didn't realize that it had a meaningful piece to me until much later in my life. That case involved an 18-year-old defendant who was accused of shining a laser light at Air One, the helicopter that the sheriff's office flies. And I didn't know it at the time, but his mother was a member of a group that I deal with from time to time. Never found out until 10 years later. But he was a young kid. He had never been in trouble before. The allegations were significant and serious. And we've had similar allegations recently with the same kind of thing going on. And the sheriff's office was very, I want to say upset, but they didn't love the idea that I resolved it with a pretrial intervention. Ultimately, when I make a filing decision, in this case, when I make a plea offer, I evaluate the entire case file. I look at a defendant's history. I look at what they do for a living. I look at what their family does as much as I can. I look at the facts. I consider what the victim says and honor what their wishes are for as much as I can. And I look at the law and I look at, can I prove it? The 4-part test we look at a case and how we resolve it. Number 1, was a crime committed? 2, can I prove it? 3, should I prove it? And number 4 is do the right thing all the time. And in this case, I use the discretion that I've been empowered with by the state attorney to cut a guy a break, cut a kid a break. He was 18 and he made a mistake. It was a grievous mistake that could have caused significant injuries. And ultimately that was a risk that I took as a prosecutor, but I felt like that was the right thing at that time. And several years later, the defendant's mother reached out to me and said, he's now a successful EMT. You have no idea what your impact on him had. He had a felony charge and it was diverted because you took a chance on him and it paid off. Now that's not always the case. And I'm sure I've made other mistakes. And if you went through my caseload, you might find where that may not have been the right call, but I believe in doing the right thing all the time because that's how I was raised.
Tell me a little bit about, you were a candidate for the public defender's office and you withdrew. Tell me a little bit about that decision-making, why you did that and what you learned as a candidate during that process. It might serve you if you were to be appointed and have a challenger.
I appreciate that opportunity to discuss this. And I spoke to my wife about this. And, we open up our lives in this process. And that's why I don't question anybody's motivations for doing this. I think everybody that puts themselves through this process is doing it for the right reasons. We open up every facet of our lives. I think it's a fair question. And I think everyone in this room and everyone in the community has a right to know why I withdrew from the public defender's race. My motivations, as I said before, on reasons I do anything professionally is public service and improve the quality of life of my family and the families in the community around me. I had a great plan of attack that I wanted to implement at the PD's office. I thought it was a once in a generational opportunity to, implement some new things at the PD's office that would be exciting and improve the efficiency, improve the representation quality. And I was in that race for a year. I announced that I was going to run in March of 2019. And my wife was with me, my family was with me, Mr. Larissa was with me. We had a great team put together. And my second daughter, Caroline, was born in January of 2020. We found out we were pregnant several weeks after I entered the campaign. We sat down together and kind of looked at each other and we said, well, let's just see how it goes. We've done it before with one. How much harder can we do two? And we learned very quickly when Caroline was born that not only was I not giving the Seventh Circuit citizens the campaign they deserved, I wasn't being the father that my children deserved, and I wasn't being the husband my wife deserved. I compound that with, and this is the part my wife has told me I should share because you have a right to hear it. My wife suffered with postpartum anxiety and postpartum depression that got pretty significant. And we made the decision that the best thing for our family and the best thing for us was for me to get out of that race and spend more time at home. I took an extended paternity leave, and then compounding all of that, COVID happened. That same month, in March, 2 months after we went home and started working from that. I don't regret the decision to withdraw at all. I don't regret the decisions I've made, and I wouldn't do this today, but for the loving support of my wife, who is absolutely the most important thing with my children to me in this entire world. Every decision I make is for their benefit. The part I learned the most about the campaign is, one, how big the circuit actually is, but two, how difficult it can be to raise money for a job that most people will never have any interaction with. It's a lesson that I think would translate well in the county bench. Obviously, whoever you choose will be standing for election in 2 years. It's a reality of this position. It's a reality of what we have to deal with on this side of the world. And it's tough to raise money for something when you can't hire someone or do a favor for people. You're not developing property. So I have learned what it takes to build a coalition, to create a committee that could raise money for me if I were honored with the selection to go forward. And, I think I'm the only one on the list. Maybe I haven't looked that closely that has actually had to stand for election or put my name in and raise money. And it is tough. It is absolutely difficult.
Does any other member have any questions?
I have some questions, Andrew. Mr. Hathaway, I saw in your application you put down that you've tried 60 cases to verdict, 30 of those being jury trials. How many of those have you tried as a first chair?
Yeah, that was an estimate. I think I would say probably half, maybe 15 of the jury trials were first chair. I think there was a period of time there where I sat on every trial that John Reed did for a 2-year period. I put 30 jury trials, and I was an estimate on bench trials. We've done a lot of different, stand your ground hearings that have a disposition on the case. It was an estimate to try to just at least demonstrate the amount of litigation I've done. I haven't kept a trial list for 7 years because I didn't see a real reason to. So it's an estimate. I'm not 100% certain. I don't have a specific number for you.
I saw you listed Travis Archer as a trial. Was that a trial?
So I talked to some former JNC members and a current JNC member, and I talked to Aaron Delgado, who was opposing counsel on it. It was an open plea with a full day sentencing. There was 2 experts, an opening, a closing. We had some very novel legal arguments. It wasn't a trial per se. It was essentially an open plea with a sentencing. And the spirit of the question, what I thought was we were wanting most recent significant substantive litigation. That's why I included it. The people I spoke to said, yeah, probably just include it and explain that's what it was. But it wasn't a jury trial per se, but we were on the verge of impaneling a jury for a finding of an upward departure under the Apprendi decision. So we thought, based on the amount of litigation that we did on it, it was more significant than most of the trials I've actually had to do, and compounded by the fact that the courtroom was full of TV cameras and standing room only audience.
Mr. Hathaway, there might be members who don't know about that case. Will you talk about that experience, what that case was, the experience, and how there's a lot of pressure on your office and you individually in that case, really from all sides. I'm sure that matured you and caused you to learn a lot. Tell me about it.
That was one of the cases where you didn't eat, you lost a lot of sleep that week. At the beginning of the Travis Archer case, it was what's been referred to as the Ponce the dog case. Travis Archer brutally beat to death his black lab puppy in his home. There was a significant amount of litigation at the outset of that case that I was not involved with. ASA Erica Kane and some of our other career criminal attorneys had handled a significant amount of litigation about the Fourth Amendment issues that were implicated by the initial arrest and the seizure of the evidence at the outset. Very interesting, all the way to the Florida Supreme Court. Ultimately, we prevailed in the pretrial litigation. As it got closer to the end, there was a lot of jockeying back and forth, whether it would be a jury trial, whether it would be an open plea with a impaneled jury on the enhancement for an upward departure argument. I was handed the case 3 weeks before. I think Brian Shorstein and I were handed the case about 3 weeks before the hearing. and they said, you know, this has been sitting for 2 years based on the appellate issues, get up to speed. And so we had to get 2 new experts. We had to have the necropsy reevaluated. We had to review all the evidence again. Meanwhile, we're getting thousands, literally thousands, boxes full of letters from the community, from people telling us if we don't put them in prison, that we're horrible people. It was a lot to digest. The media scrutiny was tremendous. Ultimately, I think we made a very just decision. We open plea. We argued for what we thought was appropriate, and we presented our case as if we did a full-on jury trial. I think we had, and the other reason I wanted to include it was very well run. We stipulated to most of the evidence. Aaron and I worked together pre-trial to make sure that everything was appropriate. We used each other's equipment. We used each other's evidence. And I think all in all, it was an extremely well done evidentiary hearing.
Do we have any other questions? Mr. Hathaway, the way this works, at the end of the day, we will call you. I anticipate that to be around 6 o'clock this evening, but I don't really know. It could be earlier, it could be later. Is your cell phone number ending in 70 a good way to contact you?
Yes, sir.
Okay, great. Thank you for your time this morning.
Thank you all, and I do not envy the position y'all are in. God bless you, and thank you so much for your dedication to this community. Thank you all.
Thank you.
Thank you.